Parliament's Section 194 committee tasked with the Public Protector's impeachment has unanimously resolved to proceed with its work. The committee says there's no legal basis for it not to do so. It further gave permission to Parliament's constitutional and legal services to proceed with identifying the evidence leader for the hearing. Members of the public will also be invited to provide evidence under oath in support or against the motion faced by Advocate Busisiwe Mkhwebane. Newzroom Afrika's Athi Mtongana joins us live from outside Parliament for more on that story. Look, Athi, it's taken a lot of work from Parliament and even through the courts, the contestation through the courts that has led us to this point. Parliament very adamant that it wants to sit and hold this fitness of inquiry. What happens next?
Well, Kathy, in fact, you're mentioning that Parliament wants to continue with the work of looking at the fitness of the Public Protector to hold office. They're so adamant in continuing their work that even though there is that pending judgment from the High Court, the Western Cape High Court, wherein the Public Protector there applied not only to interdict the impeachment inquiry, the Section 194 inquiry, she also wants to interdict the pending suspension by President Cyril Ramaphosa. Now, you may recall that letter that was sent to the Public Protector by the President asking her of reasons why he shouldn't suspend her. The Constitution does allow for the President to suspend the Public Protector in a case where an impeachment inquiry gets underway, which is actually underway now in Parliament. They have drafted their program, which paves the way and sets the deadlines and the time frames to when they will be meeting again, to when they'll be allowing members of the public to submit their evidence in favor or against the motion that is faced by the Public Protector. So with everything that is happening, including that pending outcome from the High Court, also including that application to rescind the dismissal of the rescission application by the Constitutional Court, regardless of what the courts decide in those two matters respectively, the Apex Court and the Western Cape High Court, including the investigation by the Chief Justice on that illegal SMS that was sent to Parliament's legal counsel, wherein he said Ismail Abramji, saying that he has it on good authority that the Corn Court would dismiss the Public Protector's rescission application, and that he had it on good authority. Whether or not the Chief Justice decides the particular SMS was not supposed to have been sent, or whether the Western Cape High Court decides to proceed or to judge that particular application by the Public Protector to halt and to interdict the suspension. All of those matters are outside of what's happening right now in Parliament. They will be forging ahead and continuing with the work that they are tasked to do. In fact, they now have about 2 weeks to hear back from the Public Protector. She was sent an Audi Ultram letter by Parliament's legal services, wherein she had to respond to some of the questions that were posed by the inquiry, the impeachment inquiry committee. So she also, in that particular response to the committee, has to include whether she is going to bring forward legal assistance, which is something that we know at this stage she has been permitted by the courts to do so. So she will then have to respond back within the next 2 weeks. Let's listen to what Parliament's legal services had to say around this particular matter.
On the 22nd of April, the PP was provided with an Audi notice, and members will recall that in the previous presentations we had indicated that we would give the PP an opportunity to provide a written response to the charges in the motion if she so wishes. The Audi allowed for a 30-day period that will be given to the PP to make such representations, and that 30-day period, Chair, expires on the 22nd of May, so just under 2 weeks from now. Should the PP avail that opportunity, Chair, we will of course ensure that those representations are shared with all members once received. In that same letter, Chair, we also further requested the PP to kindly indicate by the 18th of May whether she intends using a legal advisor or other expert to assist her during the hearings, and if so, to provide the committee with the details of those persons.
Athi, while the process has to go through Parliament, ultimately the person who has the final say on whether the public protector should stay or go will be the President.
Yes, in fact, the public protector said in her application at the Western Cape High Court, where she's seeking to interdict her pending suspension, she's saying there that the involvement of the President is in fact something that should be scrutinized by the courts, because she says that he can't be involved given the fact that her office, the Office of the Public Protector, is investigating the President in some of its cases, and so she feels that the President shouldn't be involved, and she feels that the President shouldn't suspend her. So pending the outcomes of the judgment by the Western Cape High Court, we don't know what the President will do in as far as moving forward is concerned. But we do know that, of course, the President has given her a couple of days to provide reasons why she shouldn't be suspended. But ultimately, when that Section 194 committee concludes its work, it will definitely be handed back to the President, as you say, who will ultimately make a decision on whether to keep the public protector in office or not. We know that her term is coming to an end next year, but she's been relentless in her fight. She's been fighting tooth and nail to actually stay in office. In fact, Parliament's legal services saying that it's something very surprising, and it's not something that is common to have an applicant apply to rescind a rescission application. So even the Crown Court there, it would be interesting to find out how they actually rule on this particular matter. But we already know in this case that last week they dismissed the public protector's rescission application because they didn't find a reasonable prospect, and they also didn't find errors that the public protector found in this particular case. But it's also going to be interesting to watch what the Chief Justice will say pertaining to that SMS, even though the MPs in that Section 194 committee feel that the SMS debacle does not directly affect the work that they have to do. The ATM and the UDM are of the view that it's crucial to find how the Chief Justice will work around that SMS investigation, and that it might actually directly impact the work that they have to do. But all other MPs and all the other political parties, including the DA, which has actually raised several motions of no confidence against Mkhwebane, are of the view that they should continue regardless of the SMS and regardless of the pending outcomes of the judgment at the Western Cape High Court.
Athi, did the committee talk about the issue of sub judice? And by here, I mean, you know, the public protector arguing that she can't discuss some of the things before Parliament in detail, as they're still being dealt with in the courts. And perhaps what she says or doesn't say in those meetings or in that inquiry may well prejudice or have an impact on the case that, she will be launching before the courts, or the multiple cases that are before the courts.
Parliament's constitutional and legal services was at pains to remind members of Parliament, particularly the ATM and the UDM, which have supported the public protector in court, particularly here in the Western Cape High Court. They were at pains to remind the MPs that they would not be discussing the merits of the applications, including that rescission application at the Apex Court, because, of course, those matters still have to be heard. We know that at the Western Cape High Court, that matter wherein the public protector applied to interdict her pending suspension and the work of the Section 194 committee, that particular case will be back in court on the 18th and the 19th, and that's when they can actually go into the merits of these cases, including that of the Constitutional Court. But at this stage, they could not go into the details. They just wanted to set the program and how they'll be moving forward, the timelines to when they'll be welcoming and receiving the evidence from members of the public who are supposed to say whether they are in favor or against the motion by Mkhwebane, and all the other necessary details that they will need. It's been interesting to look at how this work or how this committee will be working, given the fact that it's quite new for Parliament. Even the challenging of the rules by the public protector was something new for Parliament. but they've been moving swiftly, slowly but surely, Kathy. They are going to be discussing the contents of her fitness to hold office, which actually speak to the findings of that independent panel last year, which found enough prima facie evidence of incompetence against Advocate Busisiwe Mkhwebane.
All right, let's leave it there for now. Athi Mtongana out in Parliament.